Here we go. Still learning. Hello, everybody, and welcome back to Bring the Jury with Luke and Bryan Sheely of the Sheely Law Firm here in South Carolina. It's been a few weeks. We've been on some other podcasts, some guest features, which is always exciting, and just doing like lawyer stuff, which can take up a lot of your time.
If you let it.
So today we are just going to have a charcuterie board of justice, as we have stated already.
Trademark.
Yeah, trademark. I copyright that. Going to just dive in a little bit, talking about Alec Murdaugh, any updates with that, Becky Hill, jury tampering, that jazz, as well as taking a dive, sampling into the Bryan Kohberger Idaho 4 case and how that is moving along. So we will go ahead and get started with, let's start it off with Alex Murdaugh. He has officially pled guilty to the financial crimes that were so wildly discussed during his trial back in January, February of this year. So this is the first time that he's ever admitted blame to a judge. What do you guys think about that?
Well, I think that's not exactly true. I mean, he did admit guilt on the financial crimes in the murder case. I mean, Judge Newman was present, jury was present, so he has admitted guilt. But I know the tagline is, he did technically plead guilty. So yeah, that's interesting. I think it was a big part of the last status conference with Judge Newman about what's the rush on the state level. He's pleading guilty to the federal charges, and how it works in federal court is you'll enter a plea and then you won't get sentenced for a while. So Luke, what kind of interplay do you think there could be with this state trial date in around Thanksgiving, and then we have this sentencing that has not occurred? What do you think his lawyers are trying to angle for, if anything, with that?
Well, there was never going to be a trial in federal court. I think if the lawyers had their way, there would never be a financial trial in state court. I mean, he's kind of under duress, confessed all these things because he had to, because he needed to testify, because the evidence is in. But I just think that they're doing what they need to do to try to kind of hopefully get the federal side of it wrapped up. And then I think they would probably long-term strategizing wise hope that the motion for a new trial gets granted and they can kind of unravel some of the state stuff. I mean, it'd be better for him if he could be in federal custody. So I think that's the long-term goal, and not be in the Department of Corrections in South Carolina. But
yeah, Hannah and I were talking about that before we went live, about the mechanism of his ultimate goal. And he knows he's never going to walk as a free man again, but if his ultimate goal is to somehow save his name from being associated with the killing of his wife and his son, and he wants to serve that life sentence, or that rest of his life sentence, however he added up, on the financial crimes, and do it in the Bureau of Prisons in the federal system, how does he accomplish that? What's his end game? You think he's just thinking, plead to the federal charges, we got the sentencing looming, hopefully have some action on the murder conviction in terms of an appeal coming down, the motion for new trial being heard with some kind of action there? So in theory, he could be having a new trial granted, but yet being ordered to serve a sentence with the BOP. Could his whole custody get transferred?
I mean, if he's pled guilty, which he has, he will be doing a pre-sentence interview, and he'll be sentenced this fall before Judge Gergel, I imagine, or in the winter. And the question becomes,
before or after
if he can get a hearing on the motion for a new trial based on after discovered evidence and it gets granted, then there's no conviction there. That is a new trial, new pending charge. He would have no reason to be in state custody. He would be sentenced and go into federal custody, and that would be mission accomplished in terms of the better living arrangement. And I know there's some wrangling over the money and which receiver, which state court or federal court is keeping track of available funds that could be used for restitution. So,
Yeah, I mean, that's a big part of it. I know that maybe is a question down the line we've got here that Hannah's been working on for us, but who gets to dole out the money, and is there money? So I would think there's some money available, but yeah, I mean, life would be a lot easier for him in the federal prison system for so many different reasons.
Let's talk about those reasons. Like, in which ways is federal prison better than his current situation?
I mean, the state Department of Corrections is a mess. I mean, in terms of services available, in terms of just your general safety, quality of the food, your housing. I mean, Alec Murdaugh is always going to be in some kind of special housing situation due to his notoriety.
mm-hmm.
So he'll always be a little bit in a different position, but just life is always better. All of our clients that have ever served a sentence are always would prefer to do that. And I mean, who is it? Martha Stewart did a little federal bid, you know,
And he would be serving.
That looked nice. That was like a little community.
He would be serving on white collar crimes as well. So
yeah, I mean, sitting there on like a high level yard on a murder or double life sentence is a totally different game than financial sentence service in the federal BOP. I mean, it's just different. His whole world would be different. It would be a more livable experience, quality of life, all that stuff for him personally. But there's got to be a lot of wrangling right now. There's got to be a lot of maneuvering by his attorneys. It's probably one of the reasons that the South Carolina prosecutors are really looking to push those financial crimes. I mean, normally in a normal world, no one cares. I mean, people care about, victims of financial crimes, but like usually there's not a reach to do multiple trials in the state and federal system on basically the same matter. Usually the feds pick it up and the state will typically then relinquish. And that's how it goes. It's very rare to see double kind of maximum prosecution of an individual. And this is a unique situation, but I think one of the reasons that Creighton Waters and them are looking to push so hard on this trial date is for what you're just saying. If a motion for new trial gets scheduled and heard and there's testimony and it gets granted, maybe he's already scooting over into federal custody. I will say this, for just your average Joe person that's sentenced to a conviction in the South Carolina Department of Corrections, if their case ever gets overturned, whether it's on appeal or post-conviction relief, which is basically ineffective assistance of their lawyer kind of analysis, or in the rare case of a new trial for new evidence, or in this case, witness tampering, we've seen these folks just kind of sit. So, yeah, your conviction's been overturned, but yet they're just sitting in the Department of Corrections. They're not like, getting immediately sent back for a bond setting or like getting sent back to a county jail. They're just kind of languishing. And that's when you start seeing a bunch of letters to either the public defender's office or the lawyer or to the courts. Like, what am I doing here?
How long could they just be waiting for? Like, are we talking weeks, months, years? Like what?
Certainly months. And we've had people like just, we have nothing to do with their cases writing us like, hey, my case, I got a email just last week. My case got overturned. It's actually a sister on behalf of her brother. It was a murder case, got overturned. We're waiting for our news, case to start again, but he's just sitting there on the same yard that he served 5 years on before his case got overturned. What do I do? Help! How do we get this thing started? And they're just like, kind of, nothing's happening. So I doubt Murdaugh would be in that
Right.
situation. I'm sure lots of things would be happening, but yeah, I mean, bizarre.
So how does this guilty plea to 22 counts of financial fraud and money laundering in federal court affect his existing life sentence?
Wouldn't.
Okay. So that question was
Yeah, I don't think it affects it. Not a good question.
all right. Hey, they say there are no bad questions, but sometimes there are. So then, okay, so nothing would change about what's currently happening now because that was completely separate, in which we saw a lot of discussion during his trial where it was like, keep the financial crimes out of it. This has nothing to really do with the murder of his wife and son. However, that snuck in anyways. And so.
Yeah, I mean, it is always going to be a wrinkle on the state level motion for new trial. I mean, it's a law school appellate analysis, really. So, and really more about it on the appeal issue. I mean, it's probably always going to be overwhelming evidence of his guilt and the analysis, and they're going to basically say, yeah, the fact that the financial crimes came in, is it an issue to raise on a traditional appeal? Yeah, but it's not carrying water. But now that's like really kind of a jury tampering situation. If he gets a new trial, then, and he's already given testimony about it, then you have probably a new judge. Judge Newman's going to be kind of closing up his tenure in terms of his being able to be a judge in this capacity, and other reasons that I'm sure maybe the defense would not want him to be the presiding judge. But if he gets a new trial and then on the murder case and they're fighting tooth and nail, and I'm sure there'll be motions not to let any financial issues come in. And he only testified on the financials initially because he kind of had to. As Luke, would you say, under duress?
Yeah. But I mean, I think it was an error of law for him for the financials to come in the state murder case. And of course, then he had to talk about it for a day as part of his 2-day testimony. But at the end of the day, I mean, he was always going down the financials, because they're proven by bank records and wire transfers and fake forge accounts. And it was really just a matter of time. I think it contributed to him having a difficult initial trial on the murder of his family. But at the end of the day, he was always getting convicted, state, federal, on just what was clear as day in the financial case. He just didn't, it just wasn't ideal for him to have to address it while also saying, I'm a thief, but I'm not a killer. I'm a thief, but I'm not a killer. It's a difficult line to straddle.
I'm a thief and a liar, but not a killer. Right. And believe me when I say I didn't kill my family. That was more difficult.
So that's the thing. But I think it's more about where he spends his time. And I think in terms of his probably personal opinion is about his legacy. He does not like being in a convicted double murder of his family. What did Creighton Waters ask him if he was in what was the phrase he used? Patricide, or no, that's killing your father. He had some special term they looked up for a family killer. But he doesn't want to be known as that. He's a guy, I think, who could hold his hand up and say, I let my drug addiction and greed cause me to do harm to people near me and my clients, and I'm going to go down for that. But I don't think personally he really wants to be labeled as a guy who killed his wife and son. So that's a fair place to go. So I think from his perspective, pleading won't do much. And if the new trial gets redone, it's granted, then I think you have to academically look at it and go, does a jury get to know about financial crimes he's already pled to as any way, shape, or form as relative to the death of his family? And I think there might even be let's just say he gets a new trial granted, or he doesn't, and the appellate court say, hey, that really shouldn't have come in. He was prejudiced. He couldn't have a fair shot at this. This has really nothing to do with these murder cases. Then I think the prosecution would take the hint and probably wouldn't try to put it in the murder cases. Because the whole storms are coming, the whole prosecution theory to this day is that I had to kill my family to draw attention away from my financial crimes, all it did was put a microscope on him.
That never makes sense.
So like,
Mhm.
at the end of the day, he's going to do a lot of time for financial crimes. He would like to do it in federal court. State would like to life him up in Department of Corrections, and it's just a question of where he sits. But so it won't do a whole lot. Long-winded way of answering that question.
So then let's talk about this money that he has been accused of stealing. The plea deal requires him to pay back $9 million of what he's been accused of stealing. So how is that determined? And then what legal processes are involved in recovering stolen funds? Because I think in the trial back in the winter, it was very clear that he don't have any money.
Well, there's some money that is now controlled by not him.
Mhm.
That's been court ordered. I mean, his assets frozen. There's a receivership kind of situation going on. So like, I mean, there is a pot of money, because I know that his defense lawyers at one point wanted to grab some of that to pay their bills and pay their time, and they were not allowed to.
Mm.
I think now they would say, well, we're working the case for free because we're so committed to the cause. But, there's tons of different things that the defense team are doing, and the state. I mean, there was a criminal con. Did I hear about this?
No.
CrimCon.
CrimCon, like a Comic-Con?
Yeah, there's a big
Did
convention.
people dress up as Alec
I
Murdaugh?
don't know, but apparently it was a big
boy.
thing, and both Creighton Waters.
Why do we not get invited again?
I don't know. And then Murdaugh's team went, but Creighton was a star of the show. Apparently, he had a real big audience, and so there's just ways for these folks to make money. But there is some money. There's not $9 million. So like, yeah, I mean, there may be. I mean, typically how restitution works is it gets ordered by the court. And so the first step towards paying back victims. I mean, obviously there's civil litigation. You can get it done that way. But here, in terms of your traditional criminal restitution, it is ordered by the court. It gets assessed and tallied up in terms of what is going to be ordered to pay back the victims. And then it's what's ordered, and then it's how do you actually get that money.
Mm-hmm.
So if there's and that's why we have this little dispute I think we're hearing about in the media about the feds and currently it's in state control, this pot of money. And the feds, because they're willing to, if they're willing to do a plea deal to get this ball moving faster, well, they'll have a court order that orders the restitution faster than the state, who doesn't want to offer a global plea deal. We talked about that on one of our other pods. They essentially are not offering anything globally. They're offering a pound of flesh, count by count by count trial, so that they can get him with these strikes, because these financial crimes that at the state level are strike eligible, that carry strikes, 3 strikes you're out, most serious plus, another most serious, or in these financial crimes, just serious offenses. They're a strike in our system. So you line up 2 of them, and then on the 3rd, you get to serve life without parole notice, and then it's mandatory life upon conviction. So that, to the frustration of, I think, the Murdaugh defense team, they're like, we would plead if we got the kind of global, let's wrap it up, and then have a sentencing for the judge to decide. But the state is like, no, we just want convict you on one, and then, because it's easy, you already confessed in front of a jury, you swore, let's convict you on another one, and now let's serve you life notice, where the judge can only give you life, even though the sentencing range on a breach of trust with fraudulent intent may only carry 10 years. Well, guess what? Now it's eligible for life. So, the state could get their money right now and make their victims whole, but I think they're playing a game where they're interested in making sure that he gets another life sentence, because I think there is, as Creighton Waters said in the status conference, he, very dramatically, he broke the laws, not only in our state but in this very courthouse. And so the feds can do whatever they want, he did crimes in these walls, and we're going to get him in these walls. So that's basically the approach. Now, it may not get the state their restitution for their state victims, but again, these victims are very similar. There's some similar victims. So maybe the feds are going to get their victims paid back faster than the state, but the state are going to get mandatory life.
So then what happens? So talking about this pot of money that's in state's control, what happens? So let's say that, yes, they agree that he has to pay out $9 million from this pot the state has to these victims. What happens if there's 18 million? And what happens with the rest of the money that's not allocated to victims, or like, does that go to landscaping for the courthouse? Does that?
I don't think we're going to be in a situation where there's excess money. I think.
Okay.
Is that your question?
Yeah. What happens if
everybody's paid and they still seized his money?
Right. Does that happen often? Like where?
No, I mean, there's always going to have to be a court order on the amount.
Just go to like Buster, I guess, or.
I mean, if there's any money left, it'll get released back to. I mean, as long as everyone's paid. Now, again, no one's going to be paid in full. Not all victims are going to get paid unless there's some financial, money tree that has not been shaken yet. I don't think that's the case. I think they've seized everything they can. I think the courts will order to the fullest extent they can do it to pay back the victims in the criminal system. Now there's civil litigation going. I mean, there's all kinds of stuff happening where they could be getting more than just restitution, pain and suffering and all kinds of stuff. That's up to a different judge and jury. But just in terms of criminal restitution, it gets ordered. Whatever is reserved for the victims will get doled out, and that's kind of complex. But there's not going to be excess money to build a Becky Hill monument outside of of the courthouse.
Right, the Becky Hill wing.
Right. It's just going to be like, get what you can. It's going to be a money grab. I mean, essentially, in the fairest way possible to say it.
So let's talk about that timeline with how this plays into the jury tampering with Becky Hill. Would the financial crimes, and I think you guys touched on this already, but they would try to tackle that first before a potential retrial due to the jury tampering with Becky? Who,
the state or the defense?
I don't know. I guess either.
I think there's.
Like, is there a pro or con, like what would be the benefits of like the timeline falling, like whether they address financials first or the Becky Hill case moves forward? Is there like a strategy?
Well, I think right now we're waiting on a couple higher powers. I mean, we got a status conference for the state financial crimes. Judge Newman said November date. But right now, I mean, the way the motion for new trial was postured, it was basically seeking a stay of the appeal so that then we could have a motion for new trial. So, I mean, I'm not an appellate expert, but I would think the Court of Appeals would have to bite on that, issue a stay, be like, all right, fine, we'll pump the brakes. And then it'd be down to Judge Newman, assuming he didn't feel he was recused, to say, okay, let's have this hearing that it all seems everybody wants.
For the record, Judge Newman would never recuse himself on this case. That's my opinion.
Well, we've talked about that.
Yeah.
But I mean, I think, so procedurally, I don't know. I assume we would have heard something from the Court of Appeals publicly had any little note been issued down. But I just think right now it's just kind of, we're just waiting for that. I would suspect that's what needs to happen. But there's no reason why anything should stop sentencing in federal court, because that's just a totally different thing.
They're just completely separate.
And that's just going to, obviously they're paying attention to this case on the docket, but it's just going to be, all right, well, he's pled, let's do the pre-sentence report. I mean, it happens all the time. They'll schedule it.
But yeah, if I were the defense team, though, I think there is a strategy or a hope that that pre-sentencing report gets done and the federal sentencing occurs before the state level financial crime trials start. And I think that's probably because of the waiting, what's going to happen on the motion for new trial situation. Because like we said, if his end game is about custody and where is he going to serve his sentence, if one sentence goes away, you haven't yet started your state level trial, hasn't been sentenced,
Sucked in the federal
and then quickly go over to the federal system. Thank you very much. Give him my life sentence. And then the goal is achieved, and then he can continue to fight the murder case. And I think that's probably his best case scenario. And if I were Creighton Waters and them, that's why they were push. Let's get this thing tried as quick as possible, because they're thinking the same thing. We want, they're thinking we don't want whatever allegations are going off jury tampering to affect our end goal of him serving every day of his life in a crappy state prison system and just suffer. I mean, that's how personal it is, obviously. Yeah. And they don't want any Fed system coming in and taking away their glory. Again, if it's about money allocation and this kind of stuff, they could have pled them globally, but they chose not to because they want their pound of flesh.
Now, there have been so many different documentaries, Hulu has one, Netflix has one, and now even I think there's been a movie. I don't know if it was like HBO. I kind of lost track. I've only watched maybe one or two of the series. How could those media outlets like play a role in the upcoming trials? Like, are they just like, what would that look like?
I mean, it just goes back to, how do you get a fair trial? How do you get a fair trial? That's why you see gag orders in cases.
Like Kohberger, which we'll get to.
Like Kohberger, that's why really good trial lawyers, for the most part, are not making statements outside of court before trial, because they're not trying to, put more of a spotlight on a case. I mean, some cases just can't be helped. I mean, this case, I don't know if the way this case developed, I don't know if there's any scenario under which it wasn't going to be covered like this, because it is like a made for a lifetime TV special.
Right.
It's just built that way. But how do you get someone that hasn't heard about this? You can't. No one's going to say Murdaugh who? No jury in this state is going to say they have never heard of this guy. And if they did say, I haven't heard of that guy, then you got to be like, whoa, what's your functioning? Can you serve? Can you read and write?
Right.
Do you have electricity and a television set? So that's going to all be about, well, even knowing what you've heard, can you be fair and impartial? And then everyone's like, yeah, sure.
I want to be in the movie next time.
Yeah, right.
Like, trying to get my big break.
Seriously.
Or book
it's going to be like Dancing for the Stars, like auditioning to be the next Murdaugh juror.
Sure.
Well, it continues to limit a potential jury pool and who can be fair and impartial. You don't have to prove that you were unaware of this case, but once you're aware, you have to be fair and impartial, which can be difficult to really assess, because everybody wants to think they can be fair and impartial, whether they really can or not. But it's funny, like after a case like this, it was so long and so publicized, everybody did their whirlwind tour, Becky Hill included, lawyers included, judges included, make certain statements thinking it's all done. And then, it might come back. And then you're like, well, I didn't mean exactly that. So you have to be careful. So
I can't believe you didn't know about CrimeCon.
CrimeCon.
I was actually there. I just didn't watch all of that. I won't go on without you.
But it's just wild. So if I were any witness or any whatever in this case, and some media outlet said, hey, we'd love to get you take, you were so great, I'd be like, nope. But, most of them probably gave some statement to some, effect, because it was interesting, and a lot of them are proud of the work they put in to help get this conviction. But it might be that you have to be a witness again, and now you've said all this stuff. So
Crime, what is it?
CrimeCon.
CrimeCon, and run your mouth at a panel. Yeah. Could the media, could those series or movies, could the defense use those, or could the state use anything that was shared in those? I mean,
No, I don't.
Okay.
That'd probably be.
it would just be silly.
No, it'd be silly. I mean, I don't
Okay.
think there's enough in this case to.
Yeah, you could. I mean, not by the lawyers. The lawyers aren't witnesses, but if like, I mean, I don't know anything about whether like Dr. Kenny Kinsey said something, but like,
Yeah, I mean, like there are
Sorry, I thought you meant
people
like.
on these documentaries that like, I mean.
Sorry. I thought you meant like actors portraying characters, like use their.
No. I'm saying correct, in this upcoming, if there is a retrial or, even tying back into these financial crimes, like, could they be like, well, on
Yes.
Netflix, they have some of his phone calls from,
Jail.
Jail.
Yeah.
They're like talking to Buster about like different things and gambling in prison.
Sure.
any
I don't know.
potential witness, lay witness, expert witness who went out and gave a statement and got a little loosey-goosey, was like, I was just faking it, I was just BSing, but man, justice is done. I mean, yes, that could come back and you could be questioned about
There's
that.
Yeah.
a rule in state court, 608C, that is really good. Basically says any motive to impeach, any reason really can be taken up for any kind of motive for lying or deception. You can impeach the witness with it. And so like, yeah, if these star witnesses, I mean, everyone's a star in this case. Your average, I mean, the housekeeper, Kenny Kinsley, your average.
Team AM housekeeper.
Your Joe Schmo sled agent, the dogs. Anybody that did an interview after this and said anything related to the case, that could be used. Roll the footage. Potentially.
Well, I think that's probably enough with the Murdaugh circus right now. We've got a lot of people asking about Bryan Kohberger because it has been quite some time since we've talked about what's going on with Kobe. Skin suit Kobe. So we're going to go ahead and shift. If you have any remaining Alec Murdaugh questions, Becky Hill questions, feel free to send those in. And maybe we take them at the end or something. But we are going to shift to Kohberger, Kobe, as Bryan likes to say.
Yeah.
So kind of the big news that has shifted here, 2 survivors of the University of Idaho murders were allegedly awake and texting while their roommates were being killed. That's different from what we thought originally, where everyone was fast asleep.
Right.
How might this new information impact the prosecution's case against Kobe, Bryan Kohberger, BK, have it your way? And what legal challenges or implications could arise for him?
Does Burger King know that you're just a walking, talking, like ad machine, and you're like just slogan out
They need to hire me.
stuff? And
I know this has nothing to do with this. What kind of?
or is that McDonald's?
No, BK is Burger King. At BK, have it your way.
Okay.
You
there
rule. It makes no sense, but
Have it your sleigh.
I have it your I love that little jingle. They really knocked it out of the park. Anyways.
So yeah, this is interesting, Hannah. I mean, this case, because there is a gag order, because it is very sensational. If there wasn't a gag order, there would be tons of information getting out there that would be making this case a much more harder case to defend. But because there is a gag order, there's all kinds of scraps that kind of come out and people feast on these scraps from time to time. And that's essentially, I mean, yeah, that's what it is. There's dead silence, and then someone.
Reminds me of the Always Sunny in Philadelphia episode with Danny DeVito. I'm Mantis, and I'm feasting on scraps.
Right. I mean, so we've got one of the victim's fathers. So here's the source of this reporting is that one of the victim's fathers heard from his source that was a grand jury member. Some of the grand jury testimony was that 2 of the victims, living victims, were not in fact asleep during the killings, but were in fact freaking out in the rooms, texting each other.
Which I believe.
Right.
More so than just sleeping through.
Because like what we've always talked about this case is, this is a very personal, intimate, savage slaying. People would be fighting. People will be screaming.
Right.
People will be crying, kicking, fighting for their very lives. It would not be a quiet scene. I mean, no one's saying that this was a ninja assassin that was a stealth mode killer. I mean, there's a damn knife sheath left at the scene, right? So like, this would be a very chaotic, terrifying, loud moment. And so, you know, the cops were reporting through their various probable cause affidavits, and some of the limited information coming out is like, these victims that are living here don't know anything. Leave them alone. They didn't hear anything. And then it's coming out to the grand jury that in fact they were perceiving things. And so when you perceive things, then you can have recollections about what you hear, what you potentially see, your text messages, your cell phones. You know, maybe you're saying, I heard something. Well, what do you do when you hear something? You open your door and look out. Or you call your friend and say, I hear somebody screaming. Don't do that, Bob. There's no reason to do that. How could you? Or something. And so by law enforcement kind of putting a blanket over these two witnesses, they don't have knowledge because they were not awake, not perceiving an event. And then all of a sudden we find out that they were. That's astonishing.
It's crazy.
It is built. It is. I mean, it's built in impeachment to be used against law enforcement, right? Because it's a change in the story. Now, when did the change occur? I mean, it's 180 degree different narrative. And so then good defense lawyers are going to say, well, all right, well, if they weren't asleep, what did they say? Where's that information? And maybe the defense already has it, and it's just due to the gag order, but it's like still
on records, right?
Well, still, yeah, or a statement. It's still a discrepancy. And sometimes when investigation is early and it's a big publicized case, law enforcement wants to tamp down problems in a case. But if you have law enforcement not being truthful with magistrate judges for search warrants and probable cause affidavits, because like, what if these living victims said something else that could detract from a search warrant, a probable cause search warrant, or a murder warrant? I mean, this is major pretrial litigation. This is also in court, on the stand, impeachment. We have no idea what it is. Luke, I mean, what are your thoughts on how this could be used in the trial? And then I want to follow up a little bit with what apparently happened with this father.
Well, shifting stories are what get people convicted, and we know that from our clients. So that's why we always hate it when our clients give 3 or 4 different accounts, but the same can be used against law enforcement because it goes to their credibility. Why is it being hidden? Why is the official story changing? Is it to keep things under wraps, or is it to get one over on a magistrate? Or is it because the witnesses themselves, for whatever reason, lied originally to you? And then they changed their story and said they're awake once you said, hey, we got your phone records. It seems like you were awake. So why did they not be truthful with you in the first place? So it allows just a right avenue for what we as lawyers call impeachment, which is essentially layman's terms for busting you with why you weren't being honest with us, which usually indicates somebody's not being truthful for some reason.
Some sort of cover up, like with law enforcement?
Well,
I don't know. I mean,
it could be that they're protecting witnesses that were scared or confused. But if they're getting this information from the living,
I can pose a hypothesis.
Okay.
We're Ozarking it. That's what we should have.
I mean, it's why. So if you want to get a search warrant from a magistrate judge, and you want to say, here's what one living witness said. She opened the door and she saw a guy all in black with his mask, face covered, slim but athletic build, about 5'10" with bushy eyebrows. And that's not too muscular, but that's the only
very, very killer stabby looking.
Right. And that is the only bit of living victim witness testimony that goes to the magistrate, along with some other things that help support probable cause.
Right.
But that same investigator knows for sure, because they talked to the other living witnesses, that they were texting each other during the killing and were up and perceiving. And so then they either, that was being kept away from the magistrate, what the contents of their conversation, what they perceived, because maybe, like I said, one of them popped out and saw something different than the other witness. And everyone, even if there's a similar event occurring, perceives it differently than someone else. And so if you want like a true probable cause, if you're a gung-ho cop and you just want to get your search warrant and you don't want any magistrate looking too hard at this, and let's just get the evidence that we need, then you don't need 3 different people saying something 3 different ways that could have a magistrate pausing. Well, wait a second. This suspect is way different than what these 2 people said they looked out when they heard and were texting about, you look out your door first. And so let's just get these 2 out of the way. Let's deal with one. Let's get our search warrant and the evidence will convict this guy. So sometimes law enforcement thinks like that, but we have no idea. Maybe these 2 living witnesses that were texting were just said they were asleep because they were so scared, or something else is going on. Either way you cut it, it's either it's a big issue in terms of what was given to the magistrate judge, or it's an impeachment issue with law enforcement. And it's just, I don't know, it's one of those unforced errors in a investigation that you just don't, it doesn't need to be here. It's like the Becky Hill of moments, you know, you don't need to have it.
And someone had a question about, you know, if those living witnesses knew obviously what went down and didn't say anything for hours, what would that, like, what could happen to them? I mean, would that be, I mean, is that suspicious? Is that, why would you?
It would be very odd.
Yeah.
It would, sure, stuff like that can be explained away, shock, grief, whatever, denial, but at the end of the day, it does cast a lot of doubt and allows a good lawyer, defense lawyer, to say, well, why?
Mm-hmm.
Are you part of it? Did you hate her? Did you hire somebody? You know, what's the deal? I mean, that's all conspiracy theory stuff, but that kind of inconsistency allows folks' imaginations to run wild and help attack this case. So, because there's really no clear motive, there's no reason except that, you know, the public idea that he's a you know, skin suit type of guy that kind of plotted this vulnerable house. But if you have living witnesses who are kind of just sitting on this and texting each other and are having inconsistent accounts, it kind of makes you wonder why.
Wow, I cannot wait for those texts to be
Right. And the other
read aloud.
Then the other thing is you would assume that law enforcement has preserved all electronics in that home, just out of abundance of caution. But let's say they didn't, because these 2 victims were asleep and they said they didn't know, they didn't have any problems with anybody. And let's just say there was some bad investigation and that their phones were not taken and, you know, ordered to be cell brite extracted and all this kind of stuff. So like, but now there's some information that they were texting. And so that becomes, you know, information to use in a defense or in a prosecution. So it's just fascinating. But I want to get to
the dad, right?
The dad.
Okay.
So this is the father of the victim, Concal. So Steve. So he's hearing from a source about this change in information about these 2 roommates of his daughter that were texting each other during the slaying. He's hearing it from a grand jury source. And then this reporting basically says he then made efforts to contact a person involved in the grand jury process to try to figure out, like, get down to the bottom of it. Like, what are we talking about? They were awake? What do you mean they're awake? I've always been told they were asleep. And so this is a father that's grieving, hurting, hearing something massively different. And his efforts were thwarted when the FBI sent him a letter that says, hey, even though you're a victim in this case, don't think that you can't be strongly looked at for witness tampering in the grand jury process. Cease and desist all efforts. And so that kind of put the brakes on him. But, you know, it just kind of goes to show it's like an unforced error. So either you're law enforcement who are trying to keep something from a magistrate for probable cause purposes, either for a search warrant for evidence or a probable cause warrant for the murder charges, which is bad, or you are two witnesses that have initially said they were asleep and then later divulged that they were awake for some reason. So like, let's say law enforcement did grab their phones and instantly or at some point processed them and saw, you guys weren't asleep, you were texting. That's bad. Let's talk about why you initially lied to us. That's a whole other wrinkle.
Right.
It's just wild. So it's an unforced error. It's going to be fascinating. And we are now all feasting on this scrap of information.
Mantis.
But it's not little, it's huge.
It's huge.
It's huge because
It's crazy.
it's just wild. But also thwarts, defense objectives. I mean, if Luke and I have a case like this, if you remember, they were trying to get the living witness who described the assailant in this way with the all dark and covered up with bushy eyebrows, athletic build. They were trying to get her to the prelim to potentially have her testify.
Mm-hmm.
And that got quashed and something got worked out where she was then allowed to be investigated by the defense. So they instantly went, as we would do when you're triaging an investigation, let's go to the witness that was awake and perceiving stuff. But if you don't know that you have other witnesses, and let's deal with the sleeping people later. We'll follow with them about what motivations could there possibly be. We'll deal with them. But like, you want to talk to the person that gave the statement that lended itself to probable cause in part for the warrants. But if really and truly these other people were actually awake and you haven't been able to know what they're thinking or saying and why they changed their story, or law enforcement just not reveal their story, then you've lost time and it's problematic. But I imagine when this information has come out to the defense team, they're moving quickly and maybe they've known about it for a long time now. And we are just the ones that are getting the information late because of the gag order.
Might be that those sleepers are now awake and saw a very consistent, bushy-eyed, slay-looking BK killer.
Or maybe Hannah, if you're in a house.
I think I know what you're about to say. Someone else in the comments have said something. Go ahead. What were you going to say?
And if you're in a house with a bunch of roommates and it's late at night and you're hearing screaming.
People getting
hearing,
killed.
And you're not asleep, but you're texting your friend. I mean, okay.
You watching Halloween?
What else naturally would you do?
Right. So, and it's so funny because a woman, I'm assuming, commented the same thing. It's like, if you're in a house and you're hearing this ruckus go on, like your typical female, I mean, I'm just speaking from experience as a woman, I'm not going to stick my head out and be like, what's going on? Sounds really murdery out here. Like, I just want to check that y'all are okay. No, I'm immediately barricading myself. I'm not stepping out. I'm jumping out a window. I'm breaking through glass. I'm shoving crap against my door. And I'm all while calling 911, whether I'm speaking to them or not, they're on the phone.
Right. So I guess and
then chaotically yelling, like, I think my roommates are being killed.
Right. So let's say they say they're asleep, but they're actually up texting each other and not calling 911. Mm-hmm. Is that suspicious to you or weird?
Super weird. So suspicious and weird. And I mean, they are, victims and they went through an extreme amount of trauma with this. And so that's not to take away from that. And everyone, process differently, I suppose. And I've never been in that situation. So maybe I don't know how I react, but yeah, it's strange. Like, texting is also such a slow form of communication. Like, did they know that they didn't have anything to be worried about? Why are you know what I mean? That just doesn't seem urgent to me. And then to not contact law enforcement immediately or, barricade yourself in your room, break through a glass window, jump, break your ankles, but survive. Like, I don't know. Those are just things that come to my mind quickly.
And we also know there was a dog in the apartment. Most dogs are going to bark. If there's a stranger that's not one of the people that the dog's familiar with, I mean, all kinds of, there's so much on this case that we just don't know about. But it's wild.
It is extremely wild. So going back to kind of the timeline, I know that this has been, and wasn't something originally scheduled for October 18th? I don't know why I have that stuck in my head, but obviously that's no longer
Yeah.
the case. What is the updated?
So Kohberger had initially asserted his speedy trial rights, and then they're like, all right, well, this is death. We noticed you as death. And then they kind of played, we've had some episodes about how they were just playing chicken with each other. I mean, the defense team was like, we're going to be ready. And the state was like, we're ready. And look at how Raw is like, no one's trying this case in October.
Did we have a bet on this?
We did.
No, you were like, this is not happening in October.
I mean, I know I was that way.
I was saying that too. This is not,
Maybe we had a bet on
something else. But so then
October is here.
the defense was like, no, this is a death case, of course. We can't be ready in like a month. And so the judge.
It was within a year of, when's the anniversary?
Yeah, less than a year. It was super fast. I think it was November.
The judge, who I think, isn't his last name like Judge or something like that?
Something cool like that.
Judge Ball or Judge. Hauled up Kohberger and was like, all right, dude, you're going to waive your speedy trial rights so we can stop being silly. And he was like, yes, sir.
So it was silent.
Yeah, I mean, it was like, yeah, no one can try a death case this quickly. And so, yeah, it got pushed out, and there's lots of flexing going on the defense side about, like, they had a bunch of, motions to quash the indictments. Now that was filed a couple months ago. And maybe it's for something like this. I mean, if you are misrepresenting what really went on, so that'd be a Frank's violation, Luke, or whatever, Anyway, any kind of admissions to a court or magistrate assessing probable cause or lies, of course, can get a search warrant or an arrest warrant quashed. Because you can't go lying to magistrates or else our whole process fails.
And the fruits thereof.
DNA. Ooh.
An Amazon cart order.
Mm.
But see, now I'm going to Ozark a little bit. But like all of that stuff, kind of like what we already know, could be like manipulated. I mean, you know what I mean? Like online evidence, like you can create, I don't know. And DNA, I feel like, especially if somebody used to volunteer at the sheriff's department, he used to be this intern with law enforcement in the area. Like you're saying that they don't have, I don't know. They don't have his DNA on file.
Well, I mean, I think there's been a lot more than some alluding to the fact that a defense strategy concerning this DNA is going to be that it was transferred DNA on this knife sheath that may have been transferred in the evidence gathering and or collection process. And then there's a lot of information about this genealogy kind of DNA data source that it's like cart jump the horse kind of thing. Cart before the horse. So we could do a whole episode on that whole issue, and a lot of that's still being litigated and has not been turned over. So we should probably do a nice, big, huge Kohberger BK.
Someone did just correct me and say that he was never accepted as an intern. So I guess maybe he didn't work. I wonder why he was denied.
Because he's got a creepy look to him.
Yeah. No, there's so much to dive into with Bryan Kohberger, and also Rex Heuermann, who we didn't get a chance to talk about today, but we definitely need to.
We need to talk about Rex a lot because
a whole episode on Rex.
Because apparently
Beach.
There's a lot of, we're in South Carolina, and there's a lot of South Carolina connections to Rex where he's got property. There's all of a sudden people are like, oh, that guy's the guy that tried to grab my auntie. And he's got like the truck, the Avalanche. That's very kind of unique. They found in his property in Chester, and yeah, it's creepy out there.
It's
So,
creepy and murdery. It probably has some connection to South Carolina.
yeah.
Oh, no doubt. And there'll be a Netflix documentary to keep you all hooked. Well, yeah, I think that's probably a good place to stop today.
Yeah.
Again, we'll be back potentially next week. These guys are really busy with a murder trial of their own. So, we may or may not be on because justice has to happen.
Slowly but surely.
Slowly but surely. Thank you guys so much for joining. I had a few people say that they have some questions. So if you didn't have time, go ahead and drop those questions, whether it be on TikTok or on the YouTube live stream, and we can maybe address those next pod. But you guys, as always, can follow us on Instagram, TikTok, LinkedIn, MySpace, YouTube, all of the above. If you missed any bits of this episode and want to catch the full thing, it'll be uploaded this week to all major streaming platforms. So catch us there. And yeah, thank you all so much for sharing your time with us. This has been
Bring the jury.
Bring the jury.
I have to go turn off all of these. My headquarters.